land reforms in India and its consequences. Agricultural land is the most important productive resource in rural areas, and the access to land shapes the rural class structure. Historically, caste and land were linked with each other. Usually, dominant and upper caste had the control over the land, and the lower caste barely had any land. Thus, land, caste and class were intimately linked. Land had a central place in the Indian economy in the past and still holds an important place in it. Historically, land in India was not a private property and was held as a matter of traditional right. Mughal rulers have brought considerable changes in the land ownership pattern. They have imposed monetary tax on the land holdings. However, the land tenure system in modern sense evolved only during the British period. British rule made significant changes in land tenure system, and land was linked to the market for the first time. British introduced three broad systems of land tenure, namely Jamindari system, Raitwari system and Mahalwari system. However, these three systems were exploitative in nature. The main objectives of this lesson are: number one, to discuss about the concept of land reforms; number two, to discuss about the systems of land tenure in pre-independent India; number three, to discuss about the objectives and measures initiated as part of land reforms in India; fourth, critical evaluation of the implementation of land reforms in India. Systems of land tenure in pre-independent India. At the time of independence, there were three types of land tenure systems prevailing in the country: the Jamindari system, the Mahalwari system and the Raitwari system. The basic difference in these systems was regarding the mode of payment of land revenue. In the Jamindari system, the land revenue was collected from the farmers by the Jamindars. In the Mahalwari system, by the village headman on behalf of the whole village, while in the Raitwari system, the land revenue was paid to the state directly by the farmers. In all the three systems, the usual practice adopted was to get the land cultivated by tenants. Jamindari system. This system was created by the East India Company in 1793. Lord Cornwallis entered into permanent settlement with landlords with a view to increasing the revenue of the company. Under the settlement, the landlords, known as Jamindars, were declared full proprietors of large areas of land. In return, the task of collecting rent from the farmers was entrusted to them. Thus, the Jamindars were to function as intermediaries between the cultivators and the state. The share of the government in total rent collected by the Jamindars was kept at 10/11, the balance going to the Jamindars as remuneration. At the time of independence, this system was prevalent in West Bengal, Bihar, Orissa, Uttar Pradesh, Andhra Pradesh and Madhya Pradesh. The Jamindari system suffered from a number of defects. It created a unique agrarian structure in the countryside which conferred the right of sharing the produce of land without participating personally in the productive process. The system itself was based on exploitation, as it conferred unlimited rights on the jamindars to extract as much rent as they wished. According to Bhavani Sen, approximately 25% of the produce was taken away by the intermediaries in the form of rent. Mahalwari system. This system was introduced by William Bentinck in Agra and Awadh. It was later extended to Madhya Pradesh and Punjab. In this system, the whole village was treated as a unit as far as payment of land revenue is concerned. The responsibility for collecting the land revenue and depositing it in the treasury was of the village headman. Raitwari system. This system was initially introduced in Tamil Nadu and was later extended to Maharashtra, Berar, East Punjab, Assam and Coorg. Under this system, the responsibility of paying land revenue to the government was of the cultivator or individual Rayat himself, and there was no intermediary between him and the state. The Rayat had full rights regarding sale, transfer and leasing of land and could not be evicted from the land as long as he paid the land revenue. These rights were not available to the cultivators under the Jamindari system. The government defined the objectives of land reforms as follows: to remove such impediments to increase in agricultural production as arise from the agrarian structure inherited from the past, to eliminate all forms of exploitation and social injustice within the agrarian system, to provide security for the tiller of soil and assure equality of status and opportunity to all sections of the rural population. Measures contemplated to achieve these objectives can be explained like this. Number 1, abolition of intermediaries. Number 2, tenancy reforms. Number 3, ceilings on agricultural land holdings. Even before independence, it was widely recognized that the main cause of stagnation in the economy was the stagnation in the agriculture sector, and this stagnation could to large extent be attributed to exploitative agrarian relations. The chief instrument of exploitation was the jamindar, patronized and promoted by the alien government. It was on account of this reason that not only was the desirability of bringing about changes in agrarian relations accepted, but was also adopted as a kingpin of and reform policy. Approximately 57% area of the country was under the jamindari system on the eve of independence. In some states, legislations were passed for their abolition before 1951. However, most of the work relating to enactment of laws and acquisition of areas was carried out during the period of the first 5-year plan. The official documents claimed that intermediaries were completely abolished by the end of the first plan. It has been estimated that in all 173 million acres of land was acquired from the intermediaries, and as a consequence, about 2 crore tenants were brought into direct relationship with the state. Once the stage of legislation was completed and the stage of implementation started, fresh difficulties had to be faced. Zamindars were not willing to lay down their rights and privileges and turned to courts. The second 5-year plan specified that personal cultivation should have 3 elements. Number 1, risk of cultivation. Number 2, personal supervision. And number 3, labor. Though official documents claim that Zamindari system has been completely abolished, yet the fact is that it has only changed its garb. The previous Zamindars have cultivation is done with help of hired agricultural labor. They are now designated as big landowners and along with the rich peasantry have formed a new and dominant class of rural capitalists. Under the heading Tenancy Reforms, the following 3 measures are discussed. Number 1, regulation of rent. Number 2, security of tenure. And number 3, conferment of ownership rights on tenants. Regulation of rent. In the pre-independence period, the rent charged by Zamindars from the tenants was exorbitant. The British government was merely interested in its share and consequently gave unlimited powers of suppression to the Zamindars to squeeze the tenants. It has been estimated by Brijnarayan that in Punjab as much as 80% of the produce was extracted from the tenants by the Zamindars in the form of rent. In Bombay province, the rate varied between 40 to 60%. According to H.D. Malaviya, in the country as a whole, the rate varied between 43 to 75%. As a consequence, legislations were enacted after 1947 to regulate the limits of rents and reduce the burden on tenants. The first 5-year plan stated that maximum rent should be fixed at 1/4 or 1/5 of the total produce. In Punjab and Haryana, fair rent is fixed at 1/3 of the total produce. In Tamil Nadu, it is 40% of gross produce for irrigated land, 35% where irrigation is supplemented by lift irrigation, and 33.33% in other cases. In Jammu and Kashmir, landowners have been divided into 2 categories. Number 1, those holding less than 12.5 acres and those who holding more than 12.5 acres. For the former, fair the latter it has been fixed at 1/4 of total produce for wetlands and 1/3 for drylands. In Andhra area of Andhra Pradesh, fair rent is 30% of total produce for irrigated land and 25% for dry land. However, legislations fixing maximum limit of rent have been often violated. Because of the strong socio-economic and political hold of the landowners in the countryside, they have been able to extract considerably more rent from the peasants than the rent fixed by the legislations. Legislation for security of tenure had three essential aims. Number one, ejectments do not take place except in accordance with the provisions of the law. Second, land may be resumed by an owner, if at all, for personal cultivation only. And third one is, in the event of resumption, the tenant is assured of a prescribed minimum area. In all tenancy laws of the country, persons cultivating the lands of others on payment of rent, either in cash or kind or both, are treated as tenants. However, in some states like Uttar Pradesh and West Bengal, sharecroppers, that means who pay rent by division of produce, are not regarded as tenants. In some states, landowners were permitted to resume land right up to the ceiling limit, while in others the permissible limit was below the ceiling limit. Several states also passed laws requiring the landlord to leave a certain minimum area with the tenant as and when he assumes landlord for personal cultivation. For example, the laws in Kerala, Gujarat, Himachal Pradesh, Maharashtra, Karnataka, Orissa and Tamil Nadu provided that one half of the tenanted land should be left with the tenant. Laws relating to security of tenure can be implemented effectively only if correct and up-to-date land records are available. A person can claim that he is a tenant only if his name appears as such in the land records. However, it has been observed that in many states either no records of tenancy exist, or in areas where they exist are incomplete and out of date. In states of Gujarat, Haryana, Maharashtra, Punjab, Rajasthan and Uttar Pradesh, there is a provision for annual revision of records. However, several tenants do not try to get their names recorded because of the danger of being evicted. In other states, for example, Andhra Pradesh, Assam, Bihar, Karnataka, Kerala, Tamil Nadu, Orissa and West Bengal, there is no provision for annual revision of records, which are usually brought up to date after long intervals. Ownership rights for tenants. It has been repeatedly emphasized in the plan documents that ownership rights should be conferred on tenants. That is, they should be made owners of the land they cultivate. Accordingly, some states have passed legislations to confer right of ownership on tenants. West Bengal, Karnataka and Kerala have achieved more success than the other states. In West Bengal, 14 lakh sharecroppers have been recorded under the Operation Barga. In Kerala, applications of 24 lakh tenants for conferment of ownership were accepted. However, on the whole, the progress has been very unsatisfactory. A ceiling on agricultural holdings means statutory absolute limit on the amount of land which an individual may hold. The imposition of ceiling has two aspects. One is ceiling on future acquisition, and number two, ceilings on existing holdings. The first plan favored the farmer only, as the latter was expected to create enormous problems of finance, administration and management. It was only the second plan that categorically recommended imposing ceilings on existing agricultural holdings. Tea, coffee and rubber plantations, orchards where they constitute reasonably compact areas, specialized farms engaged in cattle breeding, dairying, wool raising, etc., sugarcane farms operated by sugar factories, efficiently managed farms which consist of compact blocks on which heavy investments or permanent structural improvements have been made and whose breakup is likely to lead to a fall in production. The main features of the new policy were as under. Number one, lowering of ceilings to 18 acres of wetland and 54 acres of unirrigated land. Number two, the changeover to family rather than the individual as the unit for determining land holding, lowered ceiling for a family of 5, fewer exemptions from ceilings. Fourth, retrospective application of the law for declaring benami transactions null and void. Fifth, in order to insulate the measures from challenge in courts of law, jurisdiction of civil courts has been barred. Most of these laws have been included in the 9th schedule of the Constitution, which places them beyond any challenge in courts of law on grounds of infringement of fundamental rights. Under various ceiling laws, till September 2001, 2.98 million hectares of land had been declared surplus, of which 2.18 million hectares was distributed to 5.58 million beneficiaries. This shows that only less than 2.0% land has been declared surplus, while only 1% of the total cultivated area has been actually distributed. According to the 12th 5-year plan document, only around 3 million hectares has been declared surplus so far, which is hardly 2% of net sown area in India. About 30% of this land has not yet been distributed as it is caught up in litigations. Besides, a number of benami and clandestine transactions have resulted in illegal possession of significant amounts of land above ceiling limits. The 9th 5-year plan and the 10th 5-year plan point out a new problem that has cropped up in recent years in the wake of the economic liberalization. In certain states like Karnataka, the industry and the large farmers are being given exemption from ceilings laws without seeking the permission of the Government of India. This would certainly go against the interest of the poor, as it would increase landlessness and depress agricultural wages. In this lesson, an attempt has been made to analyze the necessity of land reforms in India during the post-independence period and the objectives of land reforms and the measures contemplated to achieve the objectives of land reforms. We have elaborately discussed about the major initiatives as part of land reforms in India, such as abolition of intermediaries, tenancy reforms, ceilings on land holdings, consolidation of land holdings and cooperative farming. On the basis of this analysis, we can state that land reform measures were not much successful in India.